Prayers.
Almighty God, who in infinite wisdom and providential goodness has appointed the offices of leaders and parliaments for the welfare of society and just government of humanity, we beseech you to look upon with abundant favor these your servants whom you have been pleased to call to the performance of such important trusts in this land. Let your blessing descend upon them here assembled, and grant that they may, as in your presence, treat and consider all matters that shall come under their deliberation in so just and faithful a manner, as promote your honor and glory and to advance all the good of those whose interests you've committed to their charge. Amen.
Item 2 on the order paper, communication from the chair.
Honourable members, I welcome you to this morning's sitting. And as we had indicated earlier, it will be a short one, but we expect to be able to complete a few things before we pay tribute to the late Mr. Mainja Nkanji in the afternoon. I think Honourable Latif had something, 2 minutes. Semakula, 2 minutes.
Thank you very much, Madam Speaker. Madam Speaker, last month I raised the issue of unrestricted vis-a-vis correction at various entry points, especially Entebbe International Airport. And the Prime Minister assured this House that the responsible minister would come with a statement to this House. But up to now, we haven't seen any report to this effect. Madam Speaker, this issue is very serious, and we need an urgent answer as to why visa collection is not receipted at various entry points. And we are losing a lot of money as a result of that, Madam Speaker.
I don't know who's sitting in for the Prime Minister, but this is a very serious hemorrhage of financial resources of this country. And the Prime Minister had written, and I'd even received a copy, he had written to the Minister of Internal Affairs. So we want an answer next week, because it was more than a month ago. We want an answer next week. Honourable Semakula.
Thank you, Right Honourable Speaker. Right Honourable Speaker, yesterday in the night, there were 5 villages in Nakaseke which have been faced by land grabbings and evictions. So far, a total of not less than 20,000 people have become homeless. And actually, today's morning, they managed to raise some funds to get some transport to come here to Parliament to petition. Because there are people who are being guarded by soldiers, the land grabbers, I mean. So they are making these people to suffer a lot. As I talk now, it rained, but so many people didn't have homes where they could stay in the night. So, Right Honourable Speaker, last time I raised that issue, and you had promised to help us and guide us. But up to now, even the committee which you had told to help us hasn't done anything. So, Right Honourable Speaker, the people of Nakaseke South are suffering. They are Ugandans. It's as if they are refugees in their own country. We are asking you, Right Honourable Speaker and honourable members of Parliament and the concerned citizens of this country to help us. If our issue, Right Honourable Speaker, isn't sorted today, tomorrow the people of Nakaseke may become total refugees in their own country. I thank you.
The government chief whip had undertaken to send a team there. This Monday, was it last Monday? She had undertaken on the floor of this House to send a team.
Right Honourable Speaker, we received a delegation. But the moment these land grabbers discovered that there was something that was going to take place, so they increased the evictions. And as I've told you, more than 20,000 homes so far are homeless. They spent the nights outside their homes, which have been erased. So, Right Honourable Speaker, we usually have these committees, but they take long. And it's as if these people who are grabbing these lands have special powers from somewhere. Because everyone you talk to, they tell you that the mafias, but when you ask them, where is the face of the mafia? They tell you they are above. So I don't know, you even if you direct, Right Honorable Speaker, the committees and whatever, there is nothing that is taking place on the ground. The people of Nakaseke South, Right Honorable Speaker, want to see actions taking place. I thank you, Right Honorable Speaker.
Yeah, I wish I own land that side. And one day my neighbors came and said, next time you come, we shall not be here. I said, why? That we are being evicted. Then I asked, who is it? They failed to give me, they could not give me a name. They said, Abanen, big people. Now, who is this big person who has the capacity to just act with impunity? Honorable Minister.
Madam Speaker and honorable colleagues, it is true the government chief whip constituted a committee which went to Nakaseke. But given the urgency of the matter, after here we are going to call our system, the RDC and security, to come in as we wait for the report of the committee on Tuesday. But now we are going to have some administrative action taken today as we wait for the report of the committee. Thank you.
Attorney General.
Right Honourable Speaker and Honourable Member, in addition, on behalf of the government, we want to categorically disown whoever is unlawfully evicting people from their vivanja. The law is very clear. The protection of customary tenants or landowners is embedded within our law. Whoever is doing that is doing it in a criminal manner, and definitely the government will put in place mechanisms to identify and bring them to book.
Okay. No, I think we have agreed on how to proceed. We shall get a report on Tuesday. No, we finish with this. You did not come to ask.
Procedure, Right Honourable
No
Speaker.
procedure. Go to item 3. Item 3.
Item 3, Bills Committee stage.
Members, as you recall, we had majorly completed the bill, but we stood over a number of clauses, and some of them required the advice of the Attorney General, which would clear the way to either pass them or leave them. So I don't know whether, I know we asked the Attorney General not to go to Dokoro so that he could do this for us. Mainly on the conflict between this proposal and the Public Finance Management Act.
Madam Chair, I have looked at the provisions of the Public Finance Management Act 2015, and in particular section 29, which reads, revenue shall not be collected or received by vote, state enterprise, or public corporation, except where the vote, state enterprise, or public corporation is authorized by an act of parliament to collect or receive revenue. Now, under this law, under the insurance bill, parliament is enacting a law. Therefore, Parliament has power, if it deems it necessary and expedient, to provide that the funds, the monies received by the authority, be used by the authority for its own purposes. It is a question of what Parliament wants to do. It ceases to be a question of technicality, it's up to you members of parliament, if you think it is necessary for the authority to retain its money, provided you put it in the law under this section 29, it's okay. So, we had a meeting with all the stakeholders, and we said the only limitation was under section 29(4) of the Public Finance Management Act. 29(4) says, notwithstanding subsection 3, any revenue received by a vote, state enterprise, or public corporation in the form of fines or fees, which is refundable at a future date on fulfillment of specified conditions, shall not form part of the consolidated fund and shall be held in trust by the government in the Bank of Uganda. Now here we are saying these monies should be utilized at source. So the question of holding it in trust by the government in the Bank of Uganda cannot arise. Therefore, we agreed, and I would want to propose that we put a clause which says, notwithstanding the provisions of section 29(4) of the Public Finance Management Act 2015, all monies under subsection 1C, D, E, and F received by the authority shall be retained by the authority and used to offset the costs of administration and other expenses approved by the minister. And I want to clarify on that. What we are authorizing them to do is to retain money to offset costs of administration. But outside the costs of administration, if there are other expenses, those expenses should be approved by the minister. I beg to move.
Clarification, Honorable Attorney General.
Honorable Mwagava.
Yes, I do not have the Public Finance Management Act with me, but to my recollection, we did provide somewhere between section 34 and I think 43 that budgets for all statutory authorities and public companies must first be approved by this parliament. And if we are to approve the budgets, don't you think providing for that particular provision that they spend at source monies received as fines and whatever would contravene the spirit of parliament approving budgets for authorities such as one that is being created under this bill?
I think that's what the Attorney General was saying, that there is the rules of general application, but that there can be an exception if this House allows by an act of parliament. That's what he was. Yes. There's a window for...
No, I believe the section he has quoted in respect of receiving funds is different from the section on budget, because entirely the budget process where now statutory authorities bring their budgets to parliament for parliament to approve takes precedence over the money they have received. If parliament does not approve their budget in respect of those items, won't there be a conflict?
Honorable Attorney General.
Madam Speaker, I have not yet seen that provision.
Public finance?
Unfortunately, my colleague is not assisting me. But even if it was there, there is no contradiction. The budgets would come here, they would be approved, but the authority would receive the money and apply it to the budget as approved at source, as we are proposing. So there wouldn't be a contradiction, in my view. Even assuming there was that law, which I have not yet, that provision, which I have not yet looked at, there would be no contradiction.
Why don't we then subject the provisions of the bill as you have proposed just to the provisions of the Public Finance Management Act and leave it at that, so that in the future if we find there is a contradiction, then the Public Finance Management Act takes precedence. And if there is no contradiction, then it moves ahead.
I had put a proviso for section 29(4). If no, leaving it wide now may limit the authority we want to give, or the power we want to give the authority to apply its money. I wish I could see the provision my land colleague is pointing at, which requires, but in any event, even assuming there was in existence that provision that all budgets of corporation should come here, I do not see any contradiction. The budgets would come, they would be approved, and the monies as collected would be okay.
Honorable Obos, and then Latif.
Thank you, Honorable Attorney General, for giving way. I would like, in the same spirit, for us to recall the object of Public Finance Management Act. Why was 29 embedded as part of our legislation? And it's quite in 3, quite very mandatory. And now the 4 subsection 4 you're referring to, notwithstanding. The fear, and I think I share the same fear, if we start drafting in such a way that we allow entities to retain funds at the source, we would be amending the Public Finance Management Act without stating it. Because all other entities are interested in having their funds and they utilize. Now, the exception you wanted us to get, and I want to get it clearly, which are these other administrative expenditures that would not be foreseeable in the budgeting for them to warrant us giving an exception to the general principle, to the general rule? Which other unforeseeable administrative expenses, as you were saying? Because every entity wants to have the money at source. But this Public Finance Management Act is all inclusive, that whoever wants money should be tagged to this Public Finance Management Act. Yes.
Madam Chair, the issue of amending the Public Finance Act, Management Act by implication does not arise. Why? Because Section 29 is specific. It is on collection and deposit of revenue and retention of revenue. So the law anticipated that in some instances where Parliament deems it proper, entities may retain revenue. So if we, pursuant to this section, allow this authority to retain some revenue, we are not in any way amending the act. It was anticipated, it is properly provided for.
I think we shall have to get information. What are the special reasons why this particular one should be exempted? Honorable Latif.
I was going
Madam-
on the second leg.
Madam Chair.
The second leg, the honorable member was saying, what other administrative costs? No, look at the proposal. The proposal is that administrative costs are covered, but if there are any other expenditures other than, well, there could be, we want to be, if there are other expenditures, the minister must approve.
No, Savagara.
Madam Chair, what rings a bell in my mind is that when we create authorities, we want them to be functional. And we don't want them to be held back in as far as transacting their businesses is concerned. Madam Chair, retention of funds collected by these entities, I think when you look at the various entities we have, the UCC, Bank of Uganda, KCC, and others, they retain the money collected and even the expenditure. Our role is to really to carry out our oversight role and see whether the money is being spent the right way. Otherwise, there's no way how we could selectively say UCCE, Bank of Uganda, and others can spend as per the rules, and then we create another scenario where when it comes to IRA, then there's some kind of conflict. So I believe, Madam Speaker, Madam Chair, as it is in other entities, let these monies being collected, let it be spent, but spent in line with what has been agreed upon, other than putting in place various bottlenecks that can really cripple or hinder their most progress.
Honourable members, I don't know whether you can compare entities which were created before the Public Finance Management Act. What was the rationale of this law of 2015? Bank of Uganda is a 1964 Act. UCC was created about 10 years ago. So what was the rationale from which we should now depart? That's what we need to, why should we now depart from the principles of the Public Finance Act to allow this one to correct? We made that law in 2015. So if we have reasons to exempt it, state them so that they are recorded. Otherwise, the others were done long ago, before that law. Odur, Honorable Odur.
Thank you, Madam Chair. Normally, when contingencies or revenue is allowed to be spent at source, it is never supposed to go to administration, cost of administration, because you know administration is one of the areas that is widely abused. And then the spirit in which the minister wants the clouds to stand is not clear. What is it that the minister wants to cure by allowing the authority to spend at source? It is not coming out clearly. So I really think that since we have a Public Finance Management Act which addresses the concerns that the minister has raised, it's better we leave it out such that revenue comes to consolidated fund where we can have control over, other than allowing them to be spent at. So there are many entities. I give the example of Soroti Flying School, which is drawing money and spending at source and is under investigation because we do not have the provisions such as this to tie them. So the practice of spending money at source should be discouraged. Thank you.
So, Honorable, can you give us reasons why we should exempt this particular one?
Reason, maybe before that, I want to draw your attention, Madam Chair, to subsection 3 of section 29 of the Public Finance Management Act. A vote, state enterprise or public corporation shall retain revenue collected or received where the revenue A is in the form of levies, licenses, fees or fines, and the vote, state enterprise or public corporation is authorized through appropriation by Parliament to retain the revenue. So it's not in breach or in contravention of the principles contained in this law if we, Parliament, authorize any entity to retain monies collected at source.
Yeah, I'm just saying that for the Hansard, we need clear reasons why we should apply 29(1 so that this act permits the retention. I don't know who can help us to do
Yeah,
this.
so that our decision is informed.
Yes, so that it's not just, you don't just wake up and allow. Yes, Honorable Boss.
I must thank the Attorney General for reading verbatim 29.3, because as you've guided, Madam Speaker, the Right Honorable Chair, for this Parliament to depart from the general principle, let's put it this way, for an entity to get an authorization to use monies at source, there should be a compelling reason. And it can't just be, administrative expenses. And you give this discretion. The purpose, when I was lucky to be when they were debating this law, it was as a result of abuse. And now we are trying to streamline. The moment we start like this, you will see other laws coming and entities seeking for the same thing. Madam Speaker, Right Honorable Chair, if the compelling reason is not stated, I would advise that Honorable Chair, I think I will first get through, but I would advise that I don't see anything special. Honorable Chair or Minister of Finance should help us see the speciality.
What's your rationale for exempting this? Okay.
Madam Chairperson, when we interacted with the IRA in the process of considering the bill, what came out prominent was that we need to enact a law that complies with the ICP requirements. And one of the requirements of ICPs is that the authority should have financial independence. And if I may read verbatim for the interest of the members who are not part of the Finance Committee, and then I conclude. ICP2 provides that the supervisor, in exercise of its functions and
Maybe
powers...
You state the ICP in full for the record, because we are trying to find a compelling reason. You state the...
Madam Chair, ICP stands for Insurance Core Principles. And these are standards that govern operations of the insurance industry. And ICP2 provides that the supervisor, in the exercise of its functions and powers, is operationally independent, accountable and transparent, and has adequate resources. It goes on to state in ICP 2.4 that the supervisor and its staff are free from undue political, governmental, and industry interference in the performance of supervisory responsibilities. The supervisor is financed in a manner that does not undermine its independence. The supervisor has discretion to allocate its resources in accordance with its mandate and objectives and the risks it perceives. So, Madam Chair, it is from this background that we deemed it necessary to give the authority powers to retain the levies it collects at source and be able to spend it, obviously with approval of the board, and where other expenditures other than the administrative costs are involved, we are proposing that the minister gets to approve these expenditures. Thank you, Madam Chair.
Honourable members, you've heard the rationale. Any comments? Honourable Bose.
I thank the chair of Finance Committee, who happens to be my very good friend. I don't know whether I'm alone on this, but I don't feel that insurance core principle has helped me to appreciate the exceptional circumstances. The insurance core principles, is it captured anywhere in the, well, let me put it this way. I would have loved to get from you that the Insurance Regulatory Authority, their method of work justifies that they need this money without following ABCD. But that, where you say they should have evidence of adequate resources, is appropriated for by Parliament. I thought so. Like all other government agencies. Why must they have? The core principle does not say they must retain the money. It only refers to adequate resources. And adequate resources is the mandate of this Parliament to provide and make appropriation accordingly. Mr. Chairman of Finance Committee, I am still yearning.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I've heard the chairperson making a case for spending at source, but it is really very tempting, and I don't know why the chair, who is a member of Public Accounts Committee, is bent to take that line. Most of the cases we have in Public Accounts Committee, the accounting officers are being held responsible for, among other things, spending at source. All ministries, it is all across ministries. And even the reallocation, the ministries and departments are not supposed without the authority of Parliament. And I would have wanted the chairperson to appreciate this. You are putting restrictions to the ministries and departments, but now you are creating other bodies to say, now for you, it's okay. In the long run, you are going to have unbalanced and non-streamlined policies as government. What is so unforeseen? We insist on budgeting. Now, the core principle is to say that the insurance company, the head, should be at liberty to have finances around so that they are not under the direction of government or control. That's not really substantive enough. Information? I'll take it.
Honourable Minister of Finance.
Madam Chair, I think Honourable Sechikubo should not create an impression that, or anybody gets an impression that when we allow as Parliament an institution to spend at source, we have actually given them like an open check. No, that's not true. In the same law, we have created a board which supervises the institution, appointed by the minister. The same within our law, Parliament itself can play an oversight role to go and look at what is happening in the authority. But the issue of the sensitivity of the institution, especially where these institutions that regulate institutions that collect money from the public, we have tried, as we have done in the past, to leave them, to give them some financial independence to handle their resources, but does not take away the responsibility of Parliament or responsibility of government to go in and see if there's anything that is going wrong. And as long as we really approve it as Parliament, it will be a good thing to allow this authority to be independent to spend at source, we don't find any problem with it from the Ministry of Finance. That's why actually we moved that we give it that authority. Like we have done with Bank of Uganda, we have done with UCC, and things are moving on well. Thank you.
But when you refer to Bank of Uganda is an old institution. Which law was outside the ambit of the Public Finance and Management Act. But what is at stake here, Honorable Minister and the Chair? I really seek your indulgence. Why are you overzealous that the minister should be the one to approve those expenditures? And yet you know ministers have been culprits in all these entities we've been watching. Ministers are reckless, they force these institutions to spend on trips on really non-core items. So even the explanation you are giving, Honorable Minister, why don't you reconsider your position on this? Be kind to yourself, I know. Be kind and tell the truth and find that really what you are saying is not in tandem and the spirit of the Public Finance and Management Act. And once you sit here and you start poking holes in the laws which you create.
There's some information from Kapchula, Honorable Chakamondo.
Thank you, Madam Speaker. Madam Speaker, as an experienced minister who has been in the office in the other term of 8th Parliament, it's very important that the minister is involved. Otherwise, if you are not there, the technical people will pass out certain things without your knowledge, and still they will roll back to you. So I feel the minister's issue, it should be part of this. I thank you.
But, Honorable Chekamondo, we are totally against the principle. Not even the minister. We are not saying yes, the minister. The question here is not about the minister. We are saying it is against the spirit of the Public Finance and Management Act, because it is poking holes in the very law which was celebrated here. It was the law to curb all those expenditures so that we have Parliament having a hand in the appropriation. And this is the spirit of the Constitution. Anything going against the spirit of the Constitution by these subsidiary laws is against the legislative process, Madam Speaker. And I would feel very uncomfortable if I look on as this mischief is being perpetuated in this act.
Now, I want to ask the Minister of Finance, how do we activate 3A? It reads, a vote, state enterprise or public corporation shall retain revenue collected or received where the revenue is A, in the form of levies, licenses, fees or fines, and the vote, state enterprise or public corporation is authorized through appropriation by Parliament to retain the same. How do we activate this? At which stage do we appropriate? Do they come and report that we received 1 million shillings, and then we say, okay, you can retain it? I want to understand how we shall effect this. Because that would mean they would come to Parliament, get authority, and then we say you will retain.
Actually, what we need to know is why don't you want Parliament to appropriate for that particular authority the money they want to use in that financial year, which they have collected in the form of revenue, in the form of fees, fines, or licenses. Why don't you want us to appropriate?
Nabodu?
Thank you, Madam Chair. Additionally, I find the justification by the Honorable Chairman about independence not to hold. We have many entities in government that are supposed to be independent. The Electoral Commission, for example, the judiciary, but they're not spending at source. Does it mean that they are not independent? Running these things. Thank you.
Yes, Honorable Kapsaba.
Thank you, Madam Chair. I think I'm here to complicate things further. The AG, I think what you read, what you cited was very clear. Very, very clear. And our laws are also clear that no statute or law shall ever override our Constitution. Appropriation is an exclusive mandate of Parliament. And Madam Chair, we should never at any one time tolerate a situation where we legislate or we participate in legislation that targets at depriving this House or this Parliament of our core mandate. Colleagues have asked for a valid justification. And Madam Chair, AG and the Honorable Chair, I think, are not in a position to give a valid justification for non-authorization. So my input is that we should focus on the core principle as clearly stated in our Constitution. Then all funds have got to be, and not only appropriation. Madam Clear, Article 164(3) of our Constitution is very clear, that this Parliament shall monitor all expenditure of public funds. And this being a public institution, really this should not be an exception. Thank you, Chair.
Honourable members, Section 29(3)(a) gives the power to Parliament. I don't think we can transfer it to the Minister, just casually. Let's find a way of putting the contents of 3A into that provision so that we are within the public finance management. If we are to exempt them, this one says the Minister. Minister cannot take our powers. No, Minister cannot take our powers. Yes, with Parliament. You read it, but you are stealing the Attorney General's.
Okay, Madam Chair, notwithstanding the provision of Section 29(4) of the Public Finance Management Act 2015, all monies under subsection 1C, D, E, and F received by the authority shall be retained by the authority and used to offset the costs of administration and other expenditure approved by Parliament.
And that's the amendment we oppose. That particular amendment, we strongly oppose it because we do not want to legislate ourselves out of the appropriation process. So the section should read that all monies under subsection 1D, E, and F received by authority shall be retained by the authority and used in accordance with the provision of section 29(3) of the Public Finance Management Act.
Well, I think we achieve the same purpose, even with that formulation. It's the same. Because you see, 29(3) talks of appropriation by Parliament. In other words, it is saying, look, draw your plans, bring them to Parliament, Parliament approves them. After they have been approved, you can spend what you collect from source to implement those plans. That's okay.
But you see, Honorable Attorney General, if you use the word notwithstanding, you are literally excluding the provisions of that section. And what I'm saying, let's invoke the provisions of that section under this one to show that, yes, this authority can retain and use the money.
No, you state the formulation.
The formulation.
Yes.
Madam Chairperson, I propose that the section reads as follows. All monies under subsection 1, D, E, and F received by the authority shall be retained by the authority and used in accordance with the provisions of section 29, subsection 3 of the Public Finance Management Act.
It's okay. Okay, so, okay, I think we'll have to move it formally because we are receiving the guidance of the Attorney General first. Now let's go to, but they've captured the formulation. Okay, so I put the question that that part of the law, yes? Honorable,
I am a member of the committee. I do agree with the position given by Honorable Nwagaba, but why do we refer to the section in the Finance Management Act, supposing that section changes with time? Why don't we simply say, as appropriated by Parliament? Use the money as appropriated by Parliament. So that appropriation will be made. When they have made their plans and all that, they must come to us for us to give them approval to use that money. I beg to submit, Right Honourable Speaker.
you know, 29.1 is specific on particular forms of income. That's why I would want it to stand. If it changes, we will adjust the law. We shall adjust it. So, yeah.
I concede.
Honourable members, the question is that the proposals be amended as proposed. Those in favour say aye, the contrary no. Aye. So let's go now to the remaining clause. I think now, honourable members, we are able to move because we have resolved the principles. So where are we?
Clause 8.
Clause 8. We are now finishing
Was
up on
stood off.
Clause 8.
Madam Chair, in our records, we don't have clause 8. So maybe we need to.
Yeah, the first ones.
On mutual insurers.
There were clause 8, clause 25, and clause 33. That's the.
Okay, honourable members, I put the question that clause 8 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 25.
Clause 25? That's what we have resolved. Okay, I put the question that clause 25 be amended as has already been agreed. Those in favour say aye, the contrary no. Ayes have it.
Clause 33.
Clause 33. Yes, Honourable Chair.
Madam,
It's on licensing.
Madam
Did we
Chairperson,
resolve this?
on clause 33, you required to get the difference between health insurance organizations and health management organizations. I think that was, no, this is on, sorry, clause 33, Madam Chairperson. We had an issue on whether to take 2,000 as a currency point as proposed by the committee. And then there was another proposal of 5,000 and another proposal of 10,000. And Madam Chairperson, the harmonized position is on 5,000 currency points.
Okay, honourable members, the question is that clause 33(6) be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 1.
No,
1.
clause 33
Clause
as amended.
33 as amended.
Put the question that clause 33 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 112.
Madam Chair, we stood over clause 28 and 35.
What is in 28?
Borrowing powers, you said we needed to first resolve 25. So it would be better before we go into the hundreds to first sort out that.
In the same way, I think, but this one says with approval of Parliament, they would still have to come here because we have been saying no one should borrow, but they are required to come here. So, honourable members, I put the question that clause 28 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 28.
Put the question that clause 28, no, it has not been amended. Okay, it's not been amended.
Clause 112.
35.
Clause 35.
Clause 35, Madam Chair, you asked to understand the difference between health insurance organization and health management organization. Maybe I may be required to define, but we are proposing to delete health insurance organization.
And leave health membership organization?
Yes, HMOs.
Honourable members, you've heard the proposals. If there is no contrary opinion, put the question that clause 35 be amended as proposed. Those in favour say aye, the contrary no. Aye. Ayes have it.
Clause 35 as amended.
Put the question that clause 35 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 112.
112, I think, had also to do with the powers to
Madam Chair,
112.
clause 112 had something to do with powers of the authority in relation to financial statements and other reports. And the issue was whether the licensees should meet the costs of additional audit. And we are saying yes, and our justification is that the licensee meets the costs under normal circumstances. That is annual audit process. However, when the licensee's financial statements are not in order, they should meet the costs of the additional audit. It only applies when the financial statements have been queried. And we are saying that the authority should not be responsible for the disorganization, yes, within different entities.
Okay. Honourable members, you've heard the rationale that if your affairs are not in order, you should pay for the cost of setting them right, not that the authority should now fund it. So I put the question that clause 112 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 112 as amended.
Put the question that clause 112 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 113.
113, Honourable Chair. What was the issue?
Madam Chair, on clause 113, we propose that subject to subsection 7, we propose,
There are only 6 clauses there.
we propose to delete 7.
There are 7? They end at 6.
Madam Chairperson, in our report, we referred to 7, which was not in the bill, and we proposed to delete it. It was an anomaly.
You can't delete it, it's not there, you can't delete it.
So, in other words, we propose, we withdraw our proposal in the report.
Honourable members, the question is that clause 113. Yes.
Madam Chairperson, I could help the chairperson. If the proposal in the report is good, the only thing we need to do is to delete the words subject to subsection 7 and begin the sentence with a licensed insurer or HMO that contravenes subsection 1 or 2 commits an offense. Because the purpose of a penalty is good. So, I request the chairperson to consider only delete the words subject to subsection 7 appearing under the proposed amendment under clause 6.
I think what you see proposing to bring a new clause, is that what you're saying?
But again, the alternative Attorney General, if you could look at 5, it appears to be suggesting what's already there. So I think 6, as proposed by the chairperson, should be deleted, should not be, yeah.
Okay, honourable members, the question is that clause 113 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 124.
124.
124.
Honourable Chair.
Madam Chair, 124 was deferred on grounds that it should be defined in the interpretation clause for clarity. And Madam Chair, we have the definition, and when we get to the interpretation, we'll be able to read it.
Okay, honourable members, the question is that clause 124 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 137.
137, honourable Chair.
Madam Chair, 137 was deferred because the House wanted a justification on why the Insurance Training College should collect and retain the training levy since it's a public institution and its revenue has been subjected to Public Finance Management Act. Madam Chair, if I remember very well, we subjected this to resolving clause 25, which we have already done, and therefore this no longer stands.
Okay, the members put the question that clause 137 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 138.
138. I think we have resolved it.
Yes.
I put the question that clause 138 do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 2.
Clause 2. Honourable Chair.
Madam Chair, we propose to amend clause 2 as follows. 1, by deleting the definition of an actuary and substituting the following. Actuary means a person who is a member or a fellow of a professional institute, faculty, society, or association of actuaries and recognized by the authority. Our justification, Madam Chair, is that ICP 8 requires both qualified life and non-life actuaries. It is better for the detailed qualifications to be included in the regulations and not in the Act. 2, Madam Chair, we propose to insert immediately after the definition of commercial bank the following. Control in relation to a licensee has the meaning specified in the regulations. Constituting documents mean A, in the case of a company, its memorandum and articles of association, and B, in the case of any other entity, such document or documents that constitute and govern the entity. Our justification, Madam Chair, is to provide for the definition of control and constituting documents. 3, we propose to delete the definition of a director and substituting the following. Director means a member of the governing body of a corporate. 4, we propose to insert immediately after the definition of distribution the following. Domestic Supervisory Authority means an authority in Uganda which performs functions corresponding or similar to those performed by authority or regulates or supervises any type of financial service. Financial institution means a person who carries on or transacts in the business of a bank or accredited institution as defined in the Financial Institutions Act of 2004.
So the financial institution is a person?
Madam Chair, financial institution means a person who carries on or transacts in the business of a bank or accredited institution as defined in the Financial Institutions Act of 2004.
I think I have a problem with that. Honorable Attorney General, I think there's a problem with that.
Since the clause is already defined in another law, it is sufficient to say financial institution has the same meaning as in this act. Don't go to elaborate. Don't elaborate. Aye.
Because then you say a human person, then a corporate person, then this and that.
Madam Chair, I concede. 5, Madam Chair, by deleting the definition of foreign insurer and substituting the following. A foreign reinsurer is one incorporated and licensed as a reinsurer under the laws of a country other than Uganda, except Africa Re and PTA Re. Justification is to provide for clarity. 6, by deleting the definition of foreign supervisory authority and substituting the following. Foreign supervisory authority means an authority in a jurisdiction outside Uganda which performs functions corresponding or similar to those performed by the authority or regulates or supervises any type of financial service. Justification, Madam Chair, is that ICP 3.2.1 permits the authority to exchange information with foreign supervisors in regard to financial services and not limited to financial institutions only. 7.
Madam Chair,
Honorable Attorney General.
we can't have two definitions for the same clause. I think the chair should decide on how to, because you can't say foreign insurer means this, and then you come down and say foreign insurer means this. It must be one definition.
And I wanted to know whether you're dealing with the foreign insurer, because you said foreign insurer, then you talked about reinsurance. Are you dealing with the foreign insurer or foreign reinsurance?
You can't have two definitions for the same.
Let's work this and then address this.
Madam Chair, I think the issue of having two definitions is simple to resolve. We take one and eliminate the other.
Or you combine them.
And therefore, before that, on whether we are on foreign insurance or foreign reinsurance, I think the substance is on reinsurance. Therefore, this is the mistake in the people who typed this. Now I go to 8. In 8, we propose to delete in the definition of insurance agent and substituting the following. Insurance agent means a person appointed and authorized by an insurer to solicit for applications for insurance or negotiate insurance coverage on behalf of the insurer, or to perform other functions of an insurance nature that may be assigned to him or her by the insurer, and who, in consideration of his or her services, receives a commission or other remuneration from the insurer. Justification, Madam Chair, is to broaden the consideration and an insurance agent may receive to include any other remuneration from the insurer. 9, we propose to delete in the definition of insurance broker and substituting the following. Insurance broker means a person not being an insurance agent who, acting as an independent contractor for a commission or remuneration, negotiates or arranges insurance contracts on behalf of an insurer or prospective insured other than himself or herself, or B, advises an insured or prospective insured on his or her insurance needs and requirements. Justification, brokers do more than solicit and negotiate insurance for their clients, but also advise. 10, we propose to delete in the definition of insurance intermediary and substituting the following. Insurance intermediary means an insurance agent, an insurance broker, a risk advisor, a loss assessor, a third-party administrator, or a reinsurance broker. Justification, Madam Chair, is that the previous definition did not consider services done by intermediaries like loss assessors and on intimation of a claim. 11, we propose to delete the definition of insurer. Justification, it is to be replaced with the word licensed insurer. 12, we propose to delete the definition of internal actuary. Justification, the word is not used in the bill. 13, we propose to insert immediately after the definition of a license the following. Licensed insurer means a person who holds an insurer's license issued under section 34(1)(a). Our justification, Madam Chair, is to define who a licensed insurer is. 14, we propose to delete the words "this act" in the definition of the word life insurance business and substitute the words "the regulations." Justification, the classes of life insurance business are to be provided for in the regulations. 15,
Honorable Chairperson, I believe the issue of life insurance business is covered under the Act. And if you make a reference to it only in the regulations which are not a mandate of this August House, it would be stretching it too far. So I believe we need to retain the definition as provided for under this Act.
Additionally, and I apologize, Madam Chair, on insurer, why do we delete insurer? are we sure that throughout the act, there is nowhere we use the word insurer? Because if we use it somewhere, we must define it. Or is it that whenever we talk of insurer, it must be a licensed insurer?
Madam Chairperson, I am at a difficulty to respond to the Attorney General's issue because I cannot remember where we used the word insurer without what we are proposing. And therefore, unless he...
Where? For example, when you look at clause 115, it says in case of an insurer, the license is not in compliance with its paid. It talks of insurer.
So then it's defined.
So it is proper that we retain it, because in some cases we are using it independently of whether it's licensed or not.
Madam Chair, that's okay, but again, I need your guidance whether we need to go ahead and define a licensed insurer as well, or whether we can combine the two.
Isn't insurer more inclusive? Licensed is, I think, creating the classes of insurers.
I think the most important definition is for the insurer. Because licensing is an additional. I think a licensed
we
insurer.
need the word insurer.
Yes.
I think it's more.
So we propose to retain the provision in the bill.
Okay. Yes, you are continuing with your proposals.
Then there was Honorable Nwagaba's suggestion, which I feel is all right and we should take it. Then 15, we propose to delete in the definition of Ross assessor and substituting the following. Ross assessor means a person who by way of business investigates and negotiates the settlement of claims under insurance contracts solely on behalf of either the insurer or the insured, but does not include an individual who is an employee of an insurer or an insurance agent while acting on behalf of the insurer or insurance agent. B, an insurance agent who is authorized to settle claims on behalf of the insurer for whom the insurance agent acts as agent. Or C, a person who, acting as an expert, provides advice to a loss assessor, an insurer, or an insured on the circumstances that give rise to the claim, provided that the person does not negotiate the settlement of the claim. Our justification, Madam Chair, is to provide for a broader definition of a loss assessor.
Yes, Honorable Attorney General.
The formulation, as it was in the bill, is for me better than trying to describe and exclude. Because if you are a loss assessor, it is properly explained here. If you are not within the description, then you are not a loss assessor. Because when you go into defining and eliminating and describing, you clog it and it loses meaning. I'm suggesting that we retain what is in the bill.
Madam Chair, I concede. 16, we propose to delete in the definition of microinsurance. We propose to delete the definition of microinsurance and substituting the following. Microinsurance contract means an insurance contract approved by the authority.
Honorable Chair, I think you should not interfere with microinsurance because the definition in the bill states what it means. But now you are narrowing it to a contract. You are now moving to a contract only. The bill is defining what constitutes microinsurance. Now he wants to just concentrate on a contract.
Microinsurance means insurance for the protection of low-income people against specific perils in exchange of regular premiums, payments proportionate to the likelihood and cost of risk involved. Madam Chair, I concede.
Okay. Which one?
Madam Chair, I go to National Insurance Company. We propose to delete the definition of National Insurance Company and substitute it with the following. National Insurance Company means the company approved by the authority as a national. Sorry, Madam Chair. We propose to delete the definition of National Reinsurance Company and substituting the following. National Reinsurance Company means the company approved by the authority as a national reinsurance company of which more than 51% of the shares of the company are owned by licensees incorporated in Uganda, or the decisions of the company are arrived at by the majority who are licensees incorporated in Uganda. Our justification is provide for a more clear definition of the word National Reinsurance Company. Next, Madam Chair, we are proposing to delete the word specified in the definition of the word non-life insurance business and substituting the word prescribed. Justification, the proper word to use is prescribed. Next, we propose to delete the definition of the policyholder and substituting the following. Policyholder in relation to an insurance contract or a health benefit plan means the person who entered into the insurance contract or health benefit plan with the insurer or HMO if the rights of that person under the contract have been assigned or transferred, the person who has those rights. Justification is provided for a broader definition covering HMOs as well as assignees. Next, we propose to insert in the definition, we propose inserting immediately after the definition of the word premium the following. Reinsurance broker is a specialist intermediary involved in the placing of reinsurance. Reinsurance broker In other words, we are proposing to define reinsurance broker because the word is used in the bill. Reinsurance broker is a specialist intermediary involved in the placing of reinsurance.
Madam Chair,
No, Attorney General.
well, the latter proposition may be okay, but why not also retain the definition of premium? Oh, you are retaining?
Yes, and we are not deleting it.
Okay. Honorable Chair.
Next, Madam Chair, we propose to add a new paragraph D immediately after paragraph C in the definition of the word senior manager to read as follows. D, hold such other position or undertake such other function and duties as may be prescribed by the authority. Our justification is provide for a broader definition of who can be referred to as a senior manager, thus promoting flexibility. Yeah, we are, Madam Chair, we are. Next, Madam Chair, Madam Chair, next, the definition of the word substantial shareholder should be deleted and replaced with the following. Significant owner means a person who exercises control over a body corporate within the meaning of the regulations made under this Act. Our justification is ensure compliance with ICP 6.1, which provides for a significant owner and not a substantial shareholder. Next, we propose to insert immediately after the definition of Takaful insurance the following. Third-party administrator means a person who provides services to an HMO or a licensed insurer in relation to the administration of health benefit plan or health insurance policies. Justification is that the word is not defined and yet it is used in the bill in clause 83(1)(h). Next, we propose to insert immediately after the definition of tribunal the following. Valid license means a license that authorizes the type of activity or business being carried on by the holder of the insurance of the license for the particular time period. Justification, Madam Chair, is that ICP 4.1 requires countries to prohibit the carrying on of unauthorized insurance activities and to define the permissible legal forms of domestic insurance legal entities. Madam Chair, we have additional definitions that arose out of the debate, and I beg to...
There were two. The group and the statutory manager.
Madam Chair, we propose to define a group as follows. Group in relation to a group of which a licensed insurer is a member means a number of companies that do business in different markets under common administrative or financial control, whose members are linked by relations of interpersonal trust on the basis of similar personal, ethnic, or commercial background. Madam Chair, we propose to define a statutory manager as follows. Statutory manager means a person appointed under Section 123(3)(g) of this Act by the authority as management takeover to look after the policyholders' interests by managing the business assets and affairs of the insurer, taking into into custody any of its assets and any of its subsidiaries' assets. Madam Chair, I beg to submit.
Madam Chair, I apologize once again on the proposed definition of valid license. We don't need to qualify. We have already defined license. A license is either valid or invalid. So once we define license, we don't need to go further than that. So I propose that we delete the definition of valid license.
Because a license is a license. Either you have it or you don't.
Madam Chair, I concede.
Okay. Yes.
Thank you very much, Madam Chair. I have a problem with the qualifications or the quantification of an actuary. Madam Chair, I foresee a situation where someone will be stopped from using the title lawyer because they didn't practice law, or someone that will be stopped from using a title soil scientist because they didn't sign up with the Soil Society. Madam Chair, you're fully aware that for you even to qualify to be a lawyer, you must have gone to a law school and satisfied the requirement, the academic requirement. So what qualifies someone to be an actuarial scientist, apart from going, for instance, in Uganda, the case of Uganda, going to Makerere University, the School of Statistics, and Applied Economics, specifically the Department of Actuarial Sciences. The moment you have that qualification, then you qualify to be an actuary. We can only commit ourselves in as far as this bill is concerned.
Is there no certification for those actuaries? Is there no certificate to say you have completed this and you are now this? Is there no certification?
Certainly, Madam Chair, it's not the role of the university to certify. Now that comes to societies or institutes. The case with engineers.
What are you proposing? What are you proposing?
My proposal is that we probably insert a certified. We don't deprive people who have the qualifications of carrying the title actuary, as you're saying.
Okay, you propose.
That is what I propose, Madam Chair, that we limit, certified in this case, in as far as the bill is concerned. Certified, actuary. Thank you.
Madam Chair, for record, I have to...
All registered, Mr. Chair.
For record, I have to put a disclaimer.
Where?
Let's use the word certified, but personally, I'm not aware whether in the insurance profession the word certified is used.
Registered, maybe, I don't know.
Madam Chair, this is a critical stage. Just like any basic legislation standard, the moment we pass this bill, it will have what we call a force of law. And that is my worry, documenting this without really the relevant questions or padding. And that,
remember, let's try to arrive at a decision. Yes. Please help us define an actuary in your own wisdom and from your experience. We take your definition and move on.
No members, we really have to wind up. The body of the late remind Yakanji is outside.
I'm not yes, Madam Chair. I'm not questioning the definition of actuary. My only thing is that for this bill, we should adopt either the certification or a licensed.
But are there no people here to give us advice on that issue?
Madam Chair, I think to avoid all that, in the definition which we passed, if we just said actually means a person who is a member, an associate, or a fellow of a professional institute faculty or society or association of actuaries recognized as such. And we end there. I think we would be home and dry.
Okay.
Just that.
Madam Chair, we agree with the proposal by the Attorney General.
Okay, honourable members, the question is that clause 2 do stand, clause 2 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 2 as amended.
Put the question that clause 2 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
That title.
Put the question that the title do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Motion for the House to resume.
Hello, Minister. You don't want to move?
Madam Chair, I beg to move that the House do resume and the Committee of the whole House reports thereto.
Honourable members, the question is that the House do resume and the Committee of the whole House do report thereto. Those in favour say aye, the contrary no. Ayes have it.
Report from the Committee of the whole House. Report from the Committee of the whole House.
Honourable Minister.
Madam Speaker and honourable colleagues, I beg to report that the Committee of the whole House has considered the bill entitled the Insurance Bill 2016 and passed it with amendments.
Motion for adoption of the report from the Committee of the whole House.
Honourable Minister.
Madam Speaker, I beg to move that the report from the Committee of the whole House be adopted.
Honourable members, the question is that the report of the Committee of the whole House be adopted. Those in favour say aye, the contrary no. Ayes have it.
Bill third reading.
Honourable Minister.
Madam Speaker and honourable colleagues, I beg to move that the bill entitled the Insurance Bill 2016 be read the third time and do pass.
Now, members, I put the question that the bill be read for the third time and do pass. Those in favour say aye, the contrary no. Ayes have it.
A bill for an act entitled the Insurance Act 2017.
Title settled and bill passes. Honourable members, I want to thank you for all this effort. This has been one of the longest bills. So many amendments, almost every clause was amended, but I believe they did not lose the objectives of the bill, but I think we need to address that kind of arrangement. But in the meantime, honourable members, I want to thank you for coming and say that the body of the late Mzee Manja Nkanji is in the car park. So House adjourned to Tuesday at 2 p.m. But please return for the special sitting this afternoon. Thank you.